Good morning and welcome to the First District Court of Appeal. We have one case on the docket today, Public Supermarkets versus Department of Financial Services. Counsel, if you're ready, you may proceed.
May it please the court. My name is Bill Rogner, and along with trial counsel Ralph Douglas, I represent the appellants in this case. I'd like 5 minutes of my time for rebuttal.
So noted.
Your Honors, is a physician a pharmacist? The department says yes, and we disagree. A pharmacist is defined by statute as one licensed to practice the profession of pharmacy, which requires a pharmacy degree, a pharmacy internship, and passing the pharmacy exam. So how did we get here? Well, prior to 1994, my clients, workers' compensation employers and carriers, chose the pharmacy where the injured worker was required to fill their medications. They would get a pharmacy card or instructions in the initial packet that they got. It would say you must go to Eckerd Drugs at the time or to Walgreens to get your prescriptions filled. In 1994, in response to a crisis in coverage, the special session of the legislature redrafted the workers' compensation laws. They reduced both medical and indemnity across the board, but they did grant injured workers one thing, gave them the absolute right to select pharmacy or pharmacist for the dispensing and filling of medications under Chapter 440. It's the singular exception to the universal rule that we choose the provider of all services, subject to the jurisdiction of the JCC. And before 2020, the department agreed with our position. Injured workers could choose pharmacy or pharmacist, but absent carrier authorization, they could not choose a dispensing practitioner for the filling of prescriptions. So the rule says we can't deny dispensed medications. We're not allowed to do it. Because, as the department and the interveners say in their briefs repeatedly, the injured worker has the right to get their medications anywhere they want. Except that's not what the statute says. 440.13.3J is the enabling statute here. That's the basis of the rule. And 440.13.3J says pharmacy or pharmacist. If the legislature wanted to, they could add a comma and put in or dispensing practitioner, but they haven't. They didn't do it in 94. Dispensing practitioners existed then. They haven't done it in any of the years since then. And 440.13 has been amended at least 15 times since 1994, and they never added it in.
Well, in 2013, it looks like they did amend it to add in subsection 12, explicit reference to dispensing practitioners and their reimbursement rate. So we have, as it is currently before us, Chapter 440.13 does contemplate that dispensing practitioners do have some kind of role in dispensing medication to injured workers. So how does that fit into your argument? Okay,
that's about how they get paid. Dispensing practitioners can be authorized by carriers, and they often are. And the question is, how do they get reimbursed? That's how they get reimbursed. But this isn't about the money part; it's about the authorization part. And so here's how workers' comp works. There's pre-authorization and there's after authorization. So if we authorize something voluntarily, doctor, you're authorized to dispense, or we're ordered to by a JCC. Now the authorization part is over and the JCC's role ends. And now we switch to reimbursement, and that's what the department controls. So the question is whether we are required to authorize it. Let me give you an example that I think illustrates the issue. Many orthopedic clinics have their own in-house physical therapy facilities. When the authorized doctor prescribes physical therapy, are we required to permit the therapy to occur in the physician's office? No, we are not. We are free to send the patient to our preferred physical therapy provider, whether that's Cora, Rehab, or whoever it is. And if there's a disagreement about that decision, that authorization decision, that goes to the JCC. And here's what happens here. Happened right up until this rule it happened up until 2020 when they issued their memo, and then they adopted the rule. It's illustrated in the Todd Alea case that's in the record. So Dr. Alea is told in writing, you may not dispense. You're authorized, you're an authorized doctor, but you can't dispense in your office. Dr. Alea does it anyway. And so the injured worker did not go to the judge and say, I want you to order the carrier to authorize this service. Instead, Dr. Alea went to the department. And the bills had been denied or disallowed for the reason that was in the rule then, and it's in the rule now. It says, lack of authorization, no authorization for service rendered. And the department sided with us because the service had not been authorized. 440.13.3a says this: to be eligible for reimbursement, the healthcare provider who renders a service must receive authorization prior to rendering the service. That's what this is about. It's not about the what. It's not about the what. It's not about the Percocet. It's not about the drug. It's about where the prescription is filled. And their defense of the rule, which is necessarily based on 440.13.3j, which is about where you get the prescription filled, is based on a statement that the injured worker is entitled to get their prescription filled anywhere they want. But that's not what the statute says. And so the reason that the rule is invalid is because it expands the choice from 2 to 3. And in the M.B. Doral case, it's cited by all the parties in the brief. Judge Rowe, you were on that panel. The statute contained 2 limitations, and the rule added a 3rd. And the court said, well, you can't do that. The legislature said 2. You're not allowed to add 3 because that expands, modifies, or contravenes the enabling statute. So do I acknowledge that dispensing in an office is legal? Sure it is. No question about it. Do I acknowledge that there's a method of reimbursement for dispensed medications in workers' compensation cases? Sure. I stipulate if it's authorized. But we can't be compelled by rule to authorize any service because those decisions that we make are to be adjudicated by the JCC. Your Honor, we don't just pay the bills. That's not what we do. As you've said in your cases many, many times, this is a carrier-monitored and driven system. The statute makes it our responsibility to assure that appropriate care is delivered to the injured worker. And sometimes we dispute whether or not this physician wants to do something that's appropriate. When the doctor wants to do surgery, it's not automatically authorized just because he's an authorized doctor. The doctor has to send us a request for authorization. And, Your Honors, you see these disputes come up from JCCs all the time. The doctor says, I want to do an injection or I want to do surgery. We have a peer review doctor or a staff doctor look at it and say, that's not appropriate. So what happens? We end up with an IME doctor testifying, the treating doctor testifying, an EMA doctor testifying, and then the judge of compensation claims, who is the person charged with resolving these disputes, either says, yes, you have to authorize it, or no, you don't. So all we're saying here is that we can't be compelled by rule to authorize something. That they can't do that. And the reason that the rule is invalid is because it expands or modifies the enabling statute 440.13.3j, which allows choice of pharmacy or pharmacist.
And just to confirm, 13J was the only source of authority as an enabling statute that the department relied on at the hearing?
No, well, they listed a whole bunch of other.
Yeah, the notice of proposed rules. It lists a lot, but the only one at the hearing, that was the only one they identified.
Yes, ma'am. Ms. O'Neill conceded under cross-examination that 440.13.3j is the source. That's the one. And they just kept saying, we interpret that statute as meaning the injured worker can get their medications anywhere they want. We believe that physicians are engaged in the practice of pharmacy. And because they're engaged in the practice of pharmacy, they are then a pharmacist or a pharmacy.
And I think we saw in some of the briefing, some of the things that dispensing practitioners don't do. So they don't look for the other medications that may be prescribed necessarily unless the patient is bringing them at their self-reporting. Does a prescribing practitioner have the same reporting requirements that a pharmacist does for Schedule III drugs and other things that go under the Pharmacy Act, as far as you know?
I don't know the answer to that question, but I know this. In the pharmacy statute, it tells us what the practice of pharmacy includes. And they say, well, one of the things listed in the practice of pharmacy is dispensing, so that makes them pharmacists. But it says they do dispensing, compounding, consulting, monitoring, repackaging. Pharmacists protect us, Judge. When you go to the pharmacist with your prescription, that pharmacist looks on the record and says, wait, you just got this same prescription from another doctor. Another doctor just gave you the same prescription. Or they're going to say, wait, this prescription is dangerous in combination with this other prescription that the other doctor just gave you. All the doctor is doing in his office is prescribing and dispensing. That's all the doctor does. The doctor is not acting as a pharmacist. The doctor is acting as a doctor.
Well, a dispensing physician still has an obligation to make sure that they're prescribing and dispensing medications safely, right?
Of course, but how would that doctor have any clue that the patient is getting multiple prescriptions from multiple doctors? The doctor would have no way to know that. But again, there was a lot of comment at the workshop, both pro and con. People said it's dangerous. People said that it's way more expensive. Or, conversely, some doctors go, this is much better for patients. None of that is sworn testimony, and none of it matters. Because what this is about is the plain language of the statute. The only way I lose this case, in my estimation, is if you say, yes, a physician is a pharmacist. They are a pharmacy, which I don't think you're going to say. To me, it's plain and obvious, because what we should be looking at is 440.13.3J. Pharmacy or pharmacist, that's the choice. They gave them a third, and that's why it's invalid.
And going back to Judge Norby's question about the reimbursement provision, before this rule change and after this rule change, an employer or carrier can still say, yes, we're going to authorize this physician to dispense. So
Yes.
that would work hand in hand with that other provision.
Yes, we do it all the time.
Right.
The question is, do we have to? That's it. I mean, we're allowed to, and we do. There are plenty of physicians that they work out an agreement with the carrier, and they go, yeah, you can do all the dispensing you want. It's authorized. But when the doctor wants to dispense, he has to ask for authorization, just like he does if he wants to do surgery, just like he does if he wants to do therapy or sell DME. He prescribes a cane. They happen to sell them in their office. Do we have to authorize it in the office? No. We can say the cane is authorized, but you must go to our preferred DME provider. But for 440.13.3J, Your Honor, we would tell them what pharmacy to go to. We just can't do that. They get to choose that. Otherwise, it'd be just like it was before 94. You must go to pharmacy A. And I think the reason they gave them choice of pharmacy, because I remember I was litigating these cases, is we would say, your required pharmacy is Eckerd Drugs 18 miles from your home. And they would say, but there's a Walgreens next door. We'd say, too bad. You can't do that. You can't go there. You've got to go 18 miles away. And so they were given the right to select any pharmacy or pharmacist of their choice that would be the most convenient to the injured worker. They do not have the right to select dispensing physician. We can authorize, and we do authorize, the dispensing of medications, but we can't be forced by rule to do so. And I'll save the remainder of my time for rebuttal. Thanks.
Thank you, counsel.
May it please the Court, my name is Michael Dobson. I'm General Counsel to CFO Petronas in the Florida Department of Financial Services. The injured worker only gets to make one choice when they're navigating the workers' compensation system, and that is where they go to take possession of their prescribed medications. In the opinion of the CFO, that right is under assault here today, and that is why I wanted to come down here and personally speak with you. We heard a lot of arguments from appellants And I'd like to remind the court that the only issue properly before you on appeal today is whether or not the department's proposed rules enlarge, modify, or contravene statute. So, what does the statute say? Chapter 440.13 sub 3 sub J says, notwithstanding anything else in the workers' compensation law, the injured worker shall at all times be afforded the full, free, and absolute choice in pharmacy or pharmacist where their drugs are dispensed. Now, appellants want you to read that statute in a vacuum. The department is guided by the wisdom of Justice Scalia, and that you look at the whole text canon. As Judge Norby pointed out, 465 is referenced multiple times in Chapter 440. So the department looks to Chapter 465 to define those terms of art: pharmacist, pharmacy. What does Chapter 465 say about the practice of the profession of pharmacy? Practice of the profession of pharmacy is dispensing medication. It's consulting with patients on those dispensed medication. What does a dispensing practitioner have to do if they want to dispense medication? Well, number one, they only get to dispense medication to their patients, okay? So if an employer carrier doesn't like a practitioner dispensing medication, don't authorize that practitioner. But once you've authorized that practitioner to treat, to prescribe medication, the employer carrier no longer gets to say, all right, injured worker, you can't get the medication from that physician. You have to go somewhere else. So what does 465 say you have to do if you're a physician and you'd like to dispense medication? Well, number one, you've got to tell your licensing board you got to pay a fee. Number two, and this is in response to Judge Rowe's question, you have to adhere to all rules and regulations applicable under Chapter 465 and federal law as well, including any rules promulgated by the Board of Pharmacy. So they are subject to reporting when they dispense Schedule III controlled substance.
But are you suggesting that they also are able to access databases on all of the prescriptions that are filled, whether this patient is going to multiple doctors to fill the same prescription?
I am merely suggesting that they are beholden to following all rules and regulations provided under 465.
Okay, well, maybe I should ask the question differently. Are they performing the same functions and have the same responsibilities that pharmacists have and pharmacies?
They are dispensing medications and they're consulting with clients, and that is defined under the definition of practice of pharmacy.
Correct, but are those the only things that pharmacies and pharmacists do and are required to do?
I understand, Judge. There are all kinds of things that pharmacists do. There are different categories of pharmacists. You've got a nuclear pharmacist. That's different from a consulting pharmacist. You've got a dispensing practitioner. That's different from the pharmacist who sits behind the counter at CVS. But they are all types of pharmacists. And so the statute says you got to adhere. And finally, when you write the prescription, which is treatment, the medication has to be authorized. The who they go see has to be authorized. The what the medication is has to be authorized. And when that dispensing practitioner writes the prescription, they have to consult with the injured worker and say, you can get your medication here in my office, or you can go to a location like a CVS or a Walgreens. The statute defines that as a community pharmacy. Okay? So if a dispensing practitioner adheres to the rules of the road provided in Chapter 465, they are practicing the profession of pharmacy. And a pharmacist, as defined in 465, is anyone who is licensed to practice the profession of pharmacy. Okay? So 465 sets out this framework where if you do these things, dispensing practitioner, you are a pharmacist. Now let's talk a little bit about
so before you move on, 465 says that you can't dispense drugs unless you're a pharmacist or a dispensing practitioner.
Correct.
Right? So it seems to pretty clearly distinguish between those two things.
In that provision it does, and then there is a black letter law definition of what is a pharmacist. A pharmacist is someone authorized by Chapter 465 to practice the profession of pharmacy. And the profession of pharmacy is defined, and no one is disputing that dispensing practitioners fall within that. That is how we get there, from the plain language of 465. That's it. So what do the rules say? The rules say that medication is treatment, and it must be authorized. Okay, that's the what. The appellants have tried to say that this is somehow running over their right or their ability to authorize treatment. That's not the case. Who the patient, the injured worker goes to see, they get to authorize. What gets prescribed, they get to authorize. If that prescription is not medically necessary, they can reject it. If that doctor is in a pattern of practice of over-prescribing or over-utilizing services, they can reject it. But what the rules say they can't reject is an injured worker who wants to get their prescribed drugs from their attending physician, because that is guaranteed under 440.13 sub 3 subject.
Can they reject the dispensing practitioner for reasons of price if they're, let's say they're 150% of other pharmacies in the retail market?
So pricing is set by the legislature. This is a highly regulated area. I think that's what this dispute's really about. There are different pricing levels for a dispensing practitioner and a traditional pharmacy. It's all prescribed right there in 440. I think the answer is yes. If you are going outside of what statute says you should be charging these people, then they can and they should reject you. But they don't get to reject because of where you go to get your medication if you're an injured worker. That is not and is never an authorized reason for disallowance. So anyways, the department, we would ask, and I'll just tell you, our position is that these rules, they merely restate the law, okay? We had put out a bulletin, we entered into a settlement agreement with these folks. That settlement agreement specified we had to go into rulemaking. No good deed goes unpunished, and here we are. But the law says you're entitled to full, free, absolute choice of pharmacist. The definition of the word pharmacist includes a dispensing practitioner who acts in accordance with Chapter 465. The department is convinced that the plain language of the statute is how we get there. That is
so
what,
assuming that we ultimately do not agree with the department's contention that dispensing practitioners do fall under the term pharmacist in 3J, is there any other source of authority or enabling statutes that would support what the proposed rules do?
in terms of our authority to adopt, there was a comment earlier that all we had was 440.13J. That's not correct. We cited, and it's on page 13 of the final order that Chief Judge Schwartz issued, we cited to various provisions that say that the department must adopt rules to ensure timely payment. The department may adopt rules to resolve disputes between carriers and providers. That rulemaking authority is also how we got to the result that we did. I would point this court back to the plain language of 465, which is referenced multiple times in 440, makes it very clear that a dispensing practitioner is encompassed within the full, free, and absolute choice provision of 440.
But assuming we didn't agree with that we didn't agree that
we
could go to, so, general statements and statutes that the department has authority to enact rules, governing reimbursement disputes, that those are general statements. What's the specific source of authority that authorizes, for example, in one of the proposed rules, reimbursement may not be disallowed or adjusted for the sole reason that the injured worker has chosen to receive medication from a practitioner registered to dispense? Like, what's the source of authority for that? Because that's really the rub in these rules.
That is the rub. I know it's cited in the brief and the final order on that page 13. I could offer supplemental briefing specifically on that, but I don't have those statute cites off the top of my head at the moment. I apologize for that. But it's in 440. So, if there are no further questions, the department would ask that this court affirm Chief Judge Schwartz's ruling that our rules did not enlarge, modify, or contravene statute, and that we did not disturb the carrier-employer's right to authorize treatment.
Thank you, counsel.
Good morning, Your Honors. My name is Virginia Daly, and it is my honor this morning to represent some of the appellees, the doctors, and the companies who support those doctors in providing necessary medical care to injured workers. As Mr. Dobson explained, there are two main points in this case. The first is that when read together, Chapters 440 and 465 make it plain that dispensing practitioners are included within the injured worker's free and full choice of where to obtain their treatment. And second, the new rules, contrary to appellate's assertions, do not interfere with the carrier's authorization of who will provide the treatment or what the treatment or medications will be. I'd like to turn to those. Well, before I do that, if I could address Judge Nordby's question about the authority, the rulemaking authority. So you asked about the specific sources of authority. Appellate's counsel stated that the agency conceded it was only 440.13.3J. That is not accurate, and there are findings of fact in the final order in paragraphs 26 and 27 that outline all of this rulemaking authority and law implemented by the proposed rules. There are also conclusions of law in the final order in paragraphs 34 through 38 that outline the various provisions in Chapter 440 that also serve as the authority for these rules. The first is 440.26B, which states that the department shall require that all bills that are disallowed by the carrier must be done so, disallowances must be done so in accordance with department rule. The second is 440.525.2 that says that the department has the authority to adopt rules relating to the timeliness and accuracy of payments and reports under 440.13. The third is 440.591, which is the department's authority to adopt rules implementing Chapter 440. And then there is section 440.13.4, which is a specific grant of rulemaking authority relating to treatment reports and authorization and payments.
But, skimming those paragraphs, certainly there are general, these statutes grant rulemaking authority. It clearly contemplates that there's going to be rules governing reimbursements and reimbursement disputes and those processes. But when you drill down into the specific basis for limiting reimbursements based on dispensing practitioners, the only source of authority is 13.3J. So just to confirm, there's no other statutory provision that would be the source of authority for the proposed rule in the specific parts that I just read.
Well, so respectfully, Your Honor, I would disagree, because you have to realize and review the workers' comp system in the context in which it operates. It's a heavily regulated system, and the legislature has stated that it's intended to be a self-effectuating system. So the goal here is to make it work without a bunch of disputes that come before you or the agency or the administrative law judges. And the way to make the system work is for the department to establish rules that demonstrate how these payment disputes are going to be resolved. What is the scope of a carrier's ability to disallow or deny or adjust payment, et cetera, and so on. You're describing it as just general rulemaking authority, but it's the authority that the department needs to make the system work.
Well, under that theory, then, let's take durable medical equipment. Could the department then promulgate a rule saying that doctors who have offices where they sell DME, that the patient must be able to choose to use that doctor to purchase from? Why not? I mean, because again, we're taking 440.13J off the table. We're just looking at the general authority.
So specifically with respect to your question, it is our position, and I believe the department's position, that any treatment medication is treatment, and within the scope of the carrier's authorization. These proposed rules do not interfere with the carrier's ability to authorize or decline to authorize any particular treatment. So whether it's DME, whether it's medication, prescription medication, or whatever it is, the carriers still have that ability. They have that ability in a variety of ways. Carriers even outlined in their brief that they have the ability, when they are authorizing a provider to provide treatment, they can limit the scope of that authorization to evaluation only.
So why can't they limit it to, treatment with the exception of prescribing? or dispensing?
The reason they can't do that is because the legislature has protected, the one and only thing that the legislature has protected for injured workers in this entire workers' comp system is their ability to choose where they get their prescription medication.
But that gets us back to
dispensed.
13J. I mean, again, we're looking at the general authority. So if you're looking at these other rules, it would seem to me that if these rules would support the department, directing payment to physicians for dispensing drugs, why not providing DME? Or even if the physician's practice has an MRI, directing that the MRI be conducted there and providing reimbursement. Why not under the general authority that you're citing us now?
Well, respectfully, Your Honor, surgeries, DMEs, physical therapy, some of the other examples used by counsel, those are subject to very specific and special authorization provisions. So in 440.13.12H, I believe, there is a provision that requires express authorization as the language for surgery and any specialty lab test or diagnostic test, et cetera, and so on. So there is a provision that deals with these specialty things, and we have to set that aside. That's been dealt with specifically as a category by the legislature. So what's left is the authorization language, the regular authorization language in 440.13.3, and that language is not interfered with by these proposed rules. So when a carrier authorizes Dr. Jones to see a patient for a wrist injury, the carrier can say, Dr. Jones, you can see and evaluate this patient, but you can't provide treatment. So that's one thing they can do on the upfront at the very outset. And two, they can identify or narrow the scope of that authorization. They can say what medications or treatments are authorized up front. And again, like the carriers have argued, that would be then something that the patient would know about before they sit in the doctor's office. They would know that there was a declining of authorization, and they could take that case to the OJCC. So nothing in these proposed rules is interfering with any of that authorization process. The carriers maintain control over who. They know who are the dispensing practitioners and who are not. That information is readily available on the Department of Health website, and they can check that anytime. They can avoid all of this altogether by simply referring their patients only to non-dispensers. So they have total control over the who, and they maintain control over the what. So the only thing we're talking about is the where, and that is the only thing that's been protected to or preserved for the injured worker. It's also worth noting in the statute, in 13.3J, and I know, Judge Norby, you're asking me to ignore it, but I can't ignore the statutory language. That provision starts with notwithstanding anything to the contrary in Chapter 440. So that sort of puts it right up at the top. The legislature is telling us, look, 440 is complicated and a lot and interconnected, but setting all that aside, we want to protect the injured worker's right to choose where they get their medication. The plain language of those words have to be read. You have to connect the dots. You can't just read these statutes in a vacuum. So if you connect the dots, you see the plain language of those words include the definition of, or include a dispensing practitioner. Your Honors, in closing, I see my time is winding down. So there are two main arguments in this challenge. In reviewing the new rules and whether they are within the department's rulemaking authority and specifically whether they're consistent with the statute, this court should find that the plain meaning of 440.13.3J, when reading 440 and 465 in concert, as you must, requires that dispensing practitioners are included in the injured worker's free and full choice of where to obtain their treatment. And second, the new rules do not interfere with the carrier's authorization of who will provide the treatment or what the treatment will be. We ask this court to reject the carrier's erroneous arguments and affirm Chief Judge Swartz's final order and the new rules. Thank you.
Thank you, counsel. Thank you both.
Okay, a lot of general provisions they relied on, but you heard it. They kept coming back to the same one, and it's the one that matters, 440.13.3J. Let me take you back to 465. It is unlawful for any person other than a licensed pharmacist to lead the public to believe that he or she is engaged in the practice of pharmacy. Doctors aren't pharmacists. Judge Long, you pointed out, the physician dispensing statute says a person may not dispense medicinal drugs unless licensed as a pharmacist, except that a practitioner authorized by law can dispense. So that means it's two different things. We have a pharmacist, and then we have this other thing, the dispensing practitioner. So one cannot get to this rule through 440.13J, which says pharmacy or pharmacist, unless one says a physician is a pharmacist. And they keep saying they're relying on the plain language of the statute, but then they say the patient has the right to get their medications anywhere they want. But the patient doesn't have the right to get the medications anywhere they want. The patient has the absolute right to go to a pharmacy or a pharmacist. So the only question this case presents is whether a physician is a pharmacist. They're not.
The appellee suggests that, and again, if we were to agree with their position, that employers, carriers can just go to doctors who don't dispense. And are there specialties where that's practical? And I'm just understanding what are the implications of us agreeing with the department and saying, yes, sure, if you want to avoid dispensing practitioners, just don't authorize any.
I'll give you an example that I deal with every day. In Orlando, two very large orthopedic groups, Jewett and Orlando Orthopedic. Orlando Orthopedic, they dispense. Jewett doesn't. That gives us one choice if they're right. I can only go to Jewett. I get a request for a one-time change, I'm now out of luck because I can't go to Orlando Orthopedic Group because they dispense. So what they're saying is, well, if you don't like it, just pick doctors that don't dispense. Okay, then do I have to pick doctors that don't have physical therapy facilities inside their clinics? Do I have to pick doctors that don't sell DME if I want to avoid that? None of that belongs in a rule, and none of it belongs with the department. These are authorization decisions that are adjudicated every day, all day, by JCCs. The where, the what, the how much, all of that goes to the JCC. Only after authorization has been granted to perform a service, 440.13.3A, healthcare provider must receive authorization for service before the service is rendered. The service here is dispensing. We're saying, no, you can't do it. And they're saying you have to. You have to because we say so. We say so because we decided in 2020 that a physician was a pharmacist, so we did the bulletin. When that failed, we did the rule. And we just simply ask you to apply the plain language of 440.13.3J. Don't say that a physician is a pharmacist because they're not, and reverse the order. Thank you.
Thank you, counsel. Thank you all. This court will now stand in recess.
All rise.